Amanda.
Good morning, Simon. How are you?
Very well indeed. Nice and relaxed and calm today.
As always.
Still a bit stressed, as you may have. Anyway, there you go. There you go. So, who do we have on this episode?
Oh, we have Patrick Cannon returning to us with his extensive knowledge, particularly I think in SDLT is going to chat to us about today. Patrick Cannon, obviously from Cannon Chambers, the first virtual barristers chambers in the UK. So we are, as always, really, really honoured to have him with us. Good morning, Patrick.
Good morning, Amanda and Simon. Nice to be with you again.
Nice to see you. So what were you thinking of covering for us today?
Well, I think we've reached a point in stamp duty and multiple dwellings relief where we've now got a substantial body of case law. Admittedly, most of it is at the first-tier tribunal level, but the cases are fairly wide-ranging and drill down to a sort of granular level of all the different aspects that go to make up a self-contained single dwelling for the purposes of multiple dwellings relief. And we also have some guidance from the upper tribunal on the general principles. So I thought it might be worth spending today really summarising where we've got to in the light of all these cases.
I think that would be absolutely invaluable to listeners, actually, because we're finding that a lot of people are almost getting on the MDR bandwagon, as it were, which of course HMRC are clearly trying to cut their path away from them if they can.
Or trying to fit into the rules I found in the past.
Yes, well, yeah.
People want to install a toilet in a barn and saying it's a dwelling.
Right. Mm. What do you think that's being driven by, apart from obviously reducing? Who do you think's driving that?
Well, there are a lot of claims companies out there,
right,
who farm the sort of land registry and Rightmove and whatever databases to look for property sales that potentially will meet a claim for multiple dwellings relief. And then the people who buy these properties typically receive 2 or 3 approaches saying, we can claim for you and we'll take a commission and we're pretty confident that you can claim it. So there has been a lot of claims made to HMRC by claims companies on behalf of purchasers, which if we're polite about it, could be said to push the envelope of MDR.
So it's a bit like the old tax avoidance scheme days where they charge a commission and probably make a promise to no win, no fee kind of thing.
Yes, exactly. And at a practical level, the position is not helped from a client's point of view by the fact that HMRC operate a process now, check later situation, which is, I talk to clients all the time and they are horribly confused by this because they'll get a refund check or a payment direct into their account or via the claims company, within about 3 weeks of the refund claim going in. And with a lot of refund companies, that's the trigger point for the commission to be final. And it's only 8 months or so later that they'll get an inquiry notice from HMRC saying that we're going to look into this. And a lot of those inquiries lead to a closure notice saying the MDR should not have been claimed.
Yeah.
And can we have the money back, please? And then that's most upsetting for some clients because in one case I dealt with, the client had spent the refund check on refurbishing and upgrading the dwelling. And then her partner got cancer. And at that point, she was being asked to refund the money to
Mm.
HMRC, which is, okay, it's not HMRC's fault. Their view is no doubt, well, you shouldn't have made the claim in the first place.
Yeah.
But it might help if there was a prominent warning with the refund letter saying, look, you know, it might be worth hanging on to this money until the 9-month inquiry period has expired. But in terms of the cases, they've been very useful in, I think, establishing boundaries. And we've now got quite a lot of practical guidance from the different judges in the first-tier tribunal. You've heard all these cases. And I know from experience, and I think I've probably done most of these cases, each judge's approach is very different and depends on their personality, their experience. For example, one judge roundly criticized HMRC for saying you couldn't have a kitchen in the main living area. In other words, you couldn't have food preparation facilities. And the judge said, well, hang on, when I was younger, I lived in plenty of bedsits where we prepared meals on a Bunsen burner. And no one said that we didn't have adequate food preparation facilities. So she put, rarely in my experience, the judge put HMRC in their place on that particular issue. But then you have other judges who respond to criticism from HMRC that a single utility meter is insufficient by saying that in their experience, it's a relatively simple matter to apportion the electricity bill between the different occupants of the different dwellings.
Mm.
So that's not really an important point. So a lot of these cases they not only depend on their own particular facts, but also on the judge's reaction to them. Another example recently was when I argued that a particular dwelling was suitable to be let on Airbnb. The response of the judge was, no, that's not the case because Airbnb guests expect a cooked breakfast to be prepared. Now, that may have been the case in San Francisco all those years ago when Airbnb was first created, but certainly in this day and age, Airbnb is usually the opposite. In fact, it's self-contained.
Yeah, definitely.
Accommodation where you prepare your own meals, self-catering. So you have to deal with some of these quirky aspects that emerge in the decisions. But I thought it might be useful really to attempt rather ambitiously a summary of some of the features of single self-contained dwellings that will satisfy the MDR requirements.
Great.
So I'm conscious that I can talk for Britain for ages uninterrupted. So I don't want to do that, obviously, because that gets rather tedious. So if I go through a number of criteria, do dive in with any thoughts you have or any questions, or if you disagree with what I'm saying, please feel free to say. So with that in mind, if we start with the question of suitability for use as a dwelling, which is the basic requirement. So I'm just using my crib sheet here. And you know how when you play with your mouse, it changes the screen?
Does it zoom in? Your mind does that. Mine zooms in and then I can't zoom it out again.
So I'm looking at a spreadsheet. I'm actually looking at the spreadsheet that I have put on my website, Cannon Chambers. And when my mouse will work properly, I've got a guide to multiple dwelling relief set out as a spreadsheet on there. It's fairly easy to find. So the first, here we go. The first and most basic criterion is suitability for use as a dwelling. Before we get into the individual aspects of what that means in practice. And HMRC say in their guidance that the test for suitability for use is more stringent than whether it forms a self-contained part of a larger dwelling. And it must be sufficiently independent to be considered a dwelling on its own. And evidence will be needed to show that each dwelling in question is sufficiently independent to count as a separate dwelling in its own right. And with that in mind, I've noticed a trend in the cases that I've done, that HMRC seem to have it in now for annexes that are physically attached to a main dwelling. And whilst they wouldn't go so far as to say they can never be independent dwellings, they do look critically at annexes that are said to be independent single dwellings, which are physically attached to the main dwelling. And they like to step back and say, well, looked at in the round, this is actually one eminently suitable as one dwelling with a nice additional area for granny or for holiday visitors, etc. And this was dealt with in Fianda, of course, which went to the upper tribunal. And the upper tribunal laid down about 7 criteria in principle for deciding whether something was suitable for use as a dwelling. For me, the headline point was the upper tribunal's confirmation that suitable for use as a single dwelling excludes adaptations or alterations that could easily be made. So if on the effective date, there's an internal lockable door missing, which could easily be replaced, you could, pop down to home base, buy a cheap door, drop it into the door jamb and the lugs that are already on the door frame, because the door was removed, say, 6 months ago, and a lock put on the door. HMRC never accepted that that was sufficient, and the upper tribunal seemed to have confirmed that suitability is tested at the effective date, and it doesn't encompass a wider meaning of simple or easy adaptations that would, in the Fianda case, of course, turn the bungalow back into a self-contained dwelling.
And that's primarily looking at effectively an internal lockable door.
No, it goes wider than that. For example, if there is the infrastructure there for a kitchen, such as plumbing and drainage and a sink, the fact that you could easily install white goods and really turn the area into a kitchen is not sufficient. You have to have the kitchen there at the effective date.
Mm-hmm.
Now, I've thought that's a bit unfair, because HMRC's own guidance says that the removal of white goods before completion will not affect the fact that it's a dwelling, it's residential property. In other words, they're naturally concerned that if you could remove the white goods from the bathroom or the kitchen, and that had an effect on the residential nature of property, then you could claim Table B commercial rates. So they're very keen to stop you arguing that. But on the other hand, they say that the removal of white goods can potentially mean you don't have a dwelling for multiple dwellings relief, because you test the suitability on the effective date. So
I suppose, unless you had some evidence on the day you completed that there was a door there and the white goods in the kitchen there, you can't really say, well, it was there, but we have no photograph.
Well, it's very interesting. In Fienda, this formed one of the grounds of appeal to the upper tribunal, because the witness, who was one of the purchasers in Fienda in the first tier tribunal, said, when I examined her, and she gave her evidence, that it was obvious to her and her husband when they viewed the property with a view to purchase, that there had in the recent past been an internal door hung in the door jamb that had been taken out. And the history of that property was that there was a self-contained bungalow that was separate from the main dwelling, that some years ago someone had erected a brick corridor to join up the two, and then remove the internal door. But her evidence to the first tier tribunal was that it was clear that there had been an internal door there in the past, and it was very easy to reinstall, rehang the door. Now, Judge Citron, in his decision, did not mention that evidence. And in fact, the way he came to his decision rested in part on there having been no evidence of a door there in the recent past. Now, we thought, with sincere respect to Judge Citron, that he had failed to record that part of Mrs. Brower's evidence. And so one of the grounds of appeal was that the decision failed to take that account of that evidence. And we had a further witness statement from Mrs. Brower saying that she did recall saying that. And I was able to say as well that as the counsel examining her, she did say it. So we had the interesting question on appeal of what happens if the evidence the judge records in his decision does not match with the recollection of the parties. And the way you're meant to deal with that, just by the way, is to request the judge's notes of the hearing, first of all, to see whether or not there was a reference to it. And if there isn't, then you've got quite an uphill struggle in establishing on appeal that the decision was wrong because vital evidence was ignored. And as the judge in the upper tribunal remarked to me on appeal, he said in the past, he's only been asked to produce his judicial notes on one occasion to clear up a confusion about what was said. And he was very grateful that he hadn't said anything rude in his notes about counsel, or he'd written his shopping list or something else. That's embarrassing in his note. But we lost on that point. Not only did the judge not accept that evidence had been given, but he went on to say in the upper tribunal that it wouldn't matter had it been given, because he took a very strict approach to suitability for use. And the very fact that you could have dropped a door into the door frame and put a bolt on it just after the effective date didn't affect the fact that at the effective date there was no door in there. So the suitability test is quite a strict test.
But don't you think that is interesting? That, I mean, I'm not familiar with the values in that case in terms of how much was actually saved by making the claim. But relatively speaking, obviously a claim for MDR is going to be made, which will potentially save a number of thousands of pounds. the cost of actually dropping that door in seems extraordinary that people don't do that. But or am I looking at it too narrowly? I just think that's, if you're going to, is it that these people are just not taking proper advice before they exchange contracts or before they complete, or where are they going wrong? Because frankly, the cost of getting a carpenter in to do that, even if it was 250 quid, is a drop in the ocean to what they would have saved.
Yeah, without being too unkind, I blame estate agents and conveyancers.
Yeah.
Because I see it at the back end. I see the consequences of failing to fit a bolt before the effective date. But they want to sell properties. In the case of agents and conveyancers, they want to do the work, in fairness to them, at the lowest possible fee, so they can get the business. Conveyancing is very competitive now.
Mm.
And conveyancers generally, particularly at the lower end or the cheaper end, are simply not geared up to providing the right stamp duty advice. And it's becoming very common now for them to say to clients, and I see this quite frequently, look, I think you may have a claim for MDR here, but I'm not equipped to decide it. And I'll only check the box on the SDLT return to make the claim if you provide me with a letter of advice from a specialist confirming I can do it. But the number of times I've seen agents in the sale particulars failing to mention a self-contained annex, which judges seize on, they really do look at the particulars in the appeal hearing and say, well, there's nothing in the sales particulars about that.
Yeah.
Or in terms of mixed use, they fail to describe the mixed uses properly.
I mean, I think that point is essential. Actually, I think that people do fail to understand that something like the sales particulars would actually form part of the evidence in bringing your claim or making the appeal in the first place. And I think it's quite extraordinary that with this particular case, for the sake of a door and a bolt, somebody hasn't just turned around to them and said, this is crazy. What are you doing?
Well, Fianda was a refund claim case after the return. And the claims company in that case was a very respectable company that, in my experience, strives to only make claims that are genuine and are fully disclosed to HMRC. So it was most unfortunate that this resulted from those facts. But nevertheless, it's given us, as practitioners, it's given us some pretty good guidance on when claims should and should not be made. It's ironic also in that case, in Fianda, that the same claims company had a similar inquiry on another matter, where on internal review, the reviewer had overturned the decision to refuse the claim and taken the view, well, a lock could have easily been fitted to the door, so I'm going to give you the relief.
Right.
And it's interesting, we wanted to admit that letter in evidence in front of the first tier tribunal in Fianda. And HMRC strongly opposed our insertion of that letter in the bundle. They said it's got nothing to do with this case. You have to judge each case on its merits. So there was a sort of 10-minute discussion at the start of the Fianda hearing with the judge as to whether that evidence could be admitted. And I think quite rightly, he said, well, I'm going to allow it and I will place whatever weight on that letter I think is appropriate, rather than exclude it. So that was interesting as well in the Fianda case in the first tier tribunal. But yes, if someone could educate conveyancers and agents about the importance of multiple dwellings relief and indeed mixed use, and not skating over the presence of a separate or separate dwellings on the property. That would be very helpful.
Well, I think it's quite an interesting one actually, because you know, obviously as a former conveyancing solicitor, you know, we were always really cautious about what was creeping into tax advice, and therefore you would always seek to outsource it if you were in a smaller firm, or go to your in-house tax department if you were in a larger firm. So it's you know, it's kind of, it's an area that's ripe for you to give it out to an expert that can give you some proper, or give your clients some proper advice. So I do think, and I do understand the fact that, you know, it's a fast-paced moving industry, and people want to get on and get it done as quickly as possible. But realistically, you know, you're still looking at 8 to 10 weeks, which gives you more than enough time to outsource it to an expert to give you decent advice, or give your client decent advice. So
I think some
obviously a bit more work.
I think they say they don't give advice, but then give their opinion anyway, which I find really bizarre.
Yeah, tricky one. Anyway, interesting.
Yeah. Just looking at some specific aspects of multiple dwellings relief. Looking at sleeping areas, for example, HMRC that say that a dwelling would be expected to have an area available for sleeping. And in Fianda, it was said that the physical attributes of both the main house and the annex must be ample to accommodate the basic domestic living needs of the occupants of each. And the annex was obviously smaller than the main house, but it adequately accommodated sleeping, etc. needs, not to mention a place to sit and relax. So the bungalow, the attached bungalow in Fianda, satisfied all the basic requirements, except for the lack of, you know, a door and privacy. And then in terms of living areas, again, HMRC say that there must be a suitable area for day-to-day living, including space for chairs, tables, cupboards, furniture, and to have visitors. And again, in Fianda, Fianda essentially agreed with that, and held that the attached bungalow in that case had sufficient, you know, living and areas and an area for visitors. Now we get on to kitchens, and this has been quite a bone of contention, because HMRC are quite adamant that the dwelling must have an area where a meal can be prepared and somewhere suitable to eat it. It's not necessary for a kitchen to have a cooker or white goods, such as a fridge or dishwasher, present at the effective date of the transaction, because they would sometimes be removed on a house sale. However, there should be space and infrastructure in place, you know, plumbing for a sink, power source for cooker, etc. And a number of the cases that have come before the tribunal have really been pushing the envelope with regard to kitchen facilities, because some of them have frankly had a mere utility area and not a kitchen as such. And so, for example, in the Wilkinson case, it was said that a lack of food preparation and washing up facilities weighs against being suitable for use as a single dwelling, although the judge said it was not determinative. But in the case of Moby, the lack of food preparation facilities in the annex was held to be an important factor. And in Mullane, Judge Heather Gething held that there must be sufficient facilities to store food, including fresh food storage in a fridge, a sink, a small worktop. But for her, the issue was whether the food could safely be cooked in the kitchen to enable the premises to be regarded as suitable for use as a dwelling. And she felt that the arrangements for the kitchen would have to be capable of satisfying building and fire regulations to allow the annex to be lawfully let. And to quote her, this is the judge, "I found it incredible that Mrs. Mullane had no knowledge, more than 2 years after making the claim for MDR in respect to the annex, were there any building regulation control or fire certificates would be required to lawfully let the annex. HMRC had raised the issue of fire safety, but not identified specific regulatory impediments to the lawful letting of the property."
Would it matter, Patrick, if you weren't going to let the property? Maybe say you were having your aging mother living in the annex. Would that matter? That it's not compliant with regulations to let it?
Well, that would fail the MDR test because the cases consistently show, and including the upper tribunal decision in Fianda, that the test is objective and it must be suitable for third parties and not someone in a special relationship.
Okay.
Who may compromise or accept compromises. And in Mullane, Judge Gething said, well, fire alarms and fire doors will be needed to give the occupants of the upper room that is in the annex time to escape in case of fire. So quite a stringent test in Mullane as to not only the presence of kitchen facilities, but to satisfy all the appropriate regulatory requirements. So it's not sufficient essentially to have a utility sink and plugged in microwave, and maybe a small fridge. The kitchen facilities have got to be more substantial than that. So independent entrances. HMRC say that each dwelling must have independent access, which could be a separate entrance from the outside of the building or from common parts of the building, such as in the case of flats. And each dwelling will require access via a lockable door. Now in Mullane, Judge Gething held that the shared use of a glass conservatory that joined the main house and the annex was irrelevant. Much to HMRC's chagrin in that case, they thought that was a killer point, that you had this sort of shared glass conservatory. And Judge Gething said that it's a common feature of the UK housing market that two separate dwellings can share a common entrance and hall. And it's irrelevant that the owner created the glass conservatory to link the main house to the annex for the better enjoyment of the main house by the main house of the annex. And the motives of the previous owner were not relevant. The glass conservatory is operating as a dividing line between the main house and the annex and provides an effective geographic separation of the two parts. So what was necessary was that there be a lockable door to both the main dwelling and the annex so that the occupants of one can't wander into the other accommodation. It's very important. People sometimes think that it's sufficient to have a lockable door into the annex. But by itself, that's not enough because the annex dwellers could then wander into the main dwelling. without a lock on the main dwelling door. And I did have one case a little while ago where I was contacted the day before completion to advise on whether there were sufficient features to claim MDR. And there were internal doors between the main dwelling and the annex, but there was no locks. And the purchaser went in the day before completion with their workmen and fitted locks to both doors. They were allowed to by the vendor. And as long as that happened before the effective date, then there were sufficient, that addressed the privacy concerns that HMRC might otherwise have in terms of lockable doors. I've mentioned utilities. That is an interesting issue. It raises two particular points. One is the physical situational positioning of the utility meters and the switchboard, and whether, say, the occupants of the annex would have to get into the main dwelling in order to reset a tripped switch, for instance, if the utility the board was in the main dwelling. And that seems to be a bit of a no-no. But if it's in a common part, such as a shared garage, that both occupants can access, that's much better. And the other aspect of utilities is whether there are separate utilities supplied to each dwelling, so that you can have separate electricity bills and decide on the consumption by each dwelling. And the judges on the whole don't regard that as particularly important. And HMRC will throw that in, typically in a closure notice where they're refusing the relief, where the other physical aspects of the accommodation don't meet the requirements. But on the whole, it's not a killer point on its own. And indeed in Mullane, Judge Gething said, well, in her experience, occupants were capable of agreeing on an apportionment of a shared supply. Same goes for heating. It's nice to have separate heating controls because, for example, in Wilkinson, the judge was not impressed that the hot water and heating controls were controlled by one set of occupants.
I think that sounds quite reasonable, actually.
Yeah.
I mean, if you want to be able to heat something or like heat up the water, I think it'd be reasonable to think that there may be some sort of separation there.
Yes, I think that's entirely.
Would HMRC insist on a separate postal address, or?
No, again, it's a nice to have. It's not a killer point. In Fianda, for example, mail delivered separately to the. But a separate postal address is a nice to have, but not a killer point. As are legal constraints. Often there is planning permission for the annex that says it's not to be occupied separately from the occupants, the family of the occupants of the main dwelling. It's not to be sold off separately. They're not helpful conditions, but again, tribunals tend not to place any great weight on that. Although I noted a worrying comment in Moby was that to be considered separate, the annex should have been capable of being sold off separately from the main dwelling. Now, I think that's probably taking things a bit too far. It's one of those comments that individual judges make based on their own impression of the relief in the case. But certainly in most cases, that would probably kill off MDR for
Yes,
annexes, because very few annexes, in my experience, I mean, particularly with listed buildings, can legally be sold off separately. Just not possible.
Yeah.
Now, we've touched on marketing materials, and tribunal of the estate agent's particulars, presenting the annex or the separate dwelling as a single dwelling. But interesting, HMRC's own guidance say that estate agents' marketing material is a useful tool to assist in consideration of how many dwellings a property might comprise. However, an estate agent's main objective is in selling the property, not in providing legislatively accurate definitions of dwellings. So this information is not determinative. Now, that's all very well, and I've quoted this on a number of occasions in tribunal, but HMRC's advocates do not hesitate to draw the judge's attention to the marketing material when, for example, in Moby, the estate agent's particulars presented the property as a single property with a lower ground floor comprised of swimming pool, snug, 2 guest bedrooms and an integral garage. So estate agent's particulars really should be examined critically when they're sent to the seller, I suppose, in draft. And the seller or the agent involved ought to, be aware of the importance of describing any separate dwellings as such, because that does play heavily when a refund claim is made. So going back to the educational point, it would be helpful if agents and indeed vendors were aware of the significant savings that MDR can bring and the importance of accurately describing the state of the property rather than glossing over the existence of separate dwelling for marketing purposes. Having said that, I'm aware of at least one London agent in mixed use who has a practice of offering to sell a commercial property with an expensive London residential property in order to get into the Table B rates.
Yeah.
Interestingly, the properties offered are often commercial lock-up garages in Wales with the London mansion. And I've not actually been asked to opine on the effectiveness of that, but I've seen it in a number of transactions. And the reaction of one solicitor was, well, of course, that doesn't work because the lock-up garage should be in England and not in Wales, because the Welsh have a separate transaction tax. And of course, that's not correct. The property can be anywhere in the world. The question is the nature of the property that one is acquiring with the residential property.
Would that trigger any kind of anti-avoidance laws? Would it be slightly contrived?
It probably might trigger the GAR. However, I would not be surprised if HMRC simply, without invoking the GAR, ran a kind of Ramsey, Furness and Dawson argument that this was an artificial construct. But they quote the GAR if necessary. And indeed, you've got to wonder out aloud, rhetorically, I'm not advising here, of course, whether such a structure, when you put it together, is something that is dotassable and ought to be reported as a scheme. And of course, as we're seeing now in recent cases, the penalties for failing to make a DOTAS disclosure are now very significant. Now, I've seen one case where HMRC are currently arguing that having gone to tribunal and established that a particular scheme should have been disclosed, they've got an order under section 314, whatever it is, that disclosure should have been made. They're now arguing for retrospective £5,000 daily penalties.
That's enormous. I suppose the estate agent could also be deemed by HMRC as an enabler of tax avoidance.
Yes, there's all sorts of difficult areas now if you seriously get into those sorts of schemes without proper advice. So at the very least, it might be wise, if you're doing that sort of thing, to make a DOTAS disclosure as a protective matter, really just to protect yourself from retrospective fines. But it's interesting overall, the amount of tax that, given the huge increase in the rates of SDLT in recent years, the difference between obtaining MDR and not can be very significant. And that is no doubt driving all these refund claims that are being made. And that leads to the difficulty, of course, that we touched on at the beginning of the process now, check later approach by HMRC.
Yeah, because I've seen some refund companies asking for 25 or 30% commission.
Whew. Yeah.
If you go back to the old days of stamp duty, it was like 50-50 kind of thing, with a promise of, if it all kind of goes pear-shaped, we'll refund you. And then, of course, then when the refund comes, then they are no longer there to refund.
Yes, and incredibly, HMRC is still pursuing clients who did these schemes back in 2010, 2012. They've opened inquiries in 2012, 9 years ago. And then, earlier this year, clients received letters saying, we're now moving to close this inquiry, having heard nothing in the meantime. And of course, the provider of the scheme, having charged 50%, is driving his Rolls Royce around Monaco.
Yes. Yeah.
Completely insulated from any claim or action by these poor people. Having, in some cases, been economical with the truth about, for example, whether the retrospective stamp duty on subsales that came in 2012 would apply to the case that they'd sold. Yeah. It's really quite upsetting, actually, the behaviour that I'm still seeing, and these people who are being chased for money that they now just simply don't have. Or they've got divorced in the meantime, or whatever.
Because many of the law firms that may have sold these schemes, I think they were also shut down by the SRA as well. So it's kind of there's no one to kind of claim off.
Yes, I mean, some of the law firms were outrageous. There was one firm in the Northeast that used to forge opinions to support. I personally had a visit from the CID in Newcastle. I got the shock of my life some years ago in my old set of chambers. My secretary rang up and said, "It's Newcastle CID here to see you." I thought, what on earth is going on? And I said, well, okay, you better show him up. He came in, he said, "Mr. Cannon, we need your help." He said, "We've got this rogue solicitor up in Sunderland who we suspect has forged counsel's opinions, and we suspect one of your opinions was fell victim to this. And a long story short, I said, yeah, of course I'll help you. The opinion had been retyped. And where I had said in the advice that this particular arrangement was not suitable for commercial transactions, the opinion had been retyped and the word "not" had been removed. I mean, that was that basic. And it wasn't me alone. I can think of 2 other counsel at the tax bar whose opinions were also forged. And that particular solicitor went to jail for some time, actually, for doing that. But we digress. I mean, into rather dark areas that happened some time ago now. But I'm pleased to say the game that I see it is a lot more open and honest and transparent. And, you know, certainly the claims I see and advise on are fully disclosed. And HMRC has the information they need to assess whether the claim is solid. And when I'm asked to advise on a refund claim, and in some cases I'm asked to actually make the claim on behalf of clients under public access, I make a point of warning them that they shouldn't spend the refund check for 9 months, because it's quite possible that HMRC will look into claims just on a routine basis. And so it wouldn't be safe to go and spend the money until you know for sure that the claim is good.
Very wise.
Yeah. So that was a fairly wide-ranging tour of MDR. I hope that was helpful.
Yeah, very much so.
And I think we've got to the point now where the case law provides a fairly comprehensive set of criteria for those considering whether a claim can be made. And it's to be hoped going forward, people will make claims with those criteria in mind and will be put off making claims that really lack substance, only to end in tears when HMRC check and decide that the claim didn't have any merits and ask for their refund back.
I agree. That's great. Very informative as always.
Yeah, thank you.
Okay, Patrick, thank you for that. We've taken up almost an hour of your time, so I'm sure you're very busy today. That's great. Thank you very much.
Yeah, thanks very much, Patrick.
All right, it's a pleasure. Thank you so much.
Cheerio. Thank you.
All the very best.
Bye.
Bye.
Bye.